Welcome, guys. So, this time I need to start from criminal law in India, objectives of criminal law. 5 objectives are widely accepted for enforcement of criminal law by punishments. See, as I told you, in civil law, the punishment can be the fine or the compensation amount of money that the accused has to pay. But in criminal law, punishment can be serving a certain period of time behind the prison, or it may also include the fine which the accused has to submit to the state or to the court, or it can be both of these, fine also and a prison term also. So there are 5 objectives to enforce the criminal law by giving punishments. What are those? Retribution, deterrence, incapacitation, rehabilitation, and restoration. Retribution. This theory basically deals with righting of balance. If a criminal has done a wrong towards a person or property, he needs to be given a penalty in a manner which balances out the wrong done. That means, as I told you, criminal law में punishment can be a prison term also or a fine also. So retribution is the amount of money or a penalty that accused has to submit which balances out the wrong which he has committed. For example, if a person has resulted in death of another person, okay, if a person has murdered another person, then obviously against him there will be charges of murder. And to compensate the victim family, it may happen that court gives a hanged to death or a certain huge amount of fine or such things. It depends upon the discretion of court. It may give a capital punishment like a life imprisonment or death ka order de court. So that is to balance out the suffering which is caused to the victim and his family, right? Because they have lost a person, so to balance that हम भी कुछ ऐसी punishment देंगे कि वो चीज़ बराबर हो जाए. एक बंदा वहाँ गया तो एक बंदा यहाँ भी जाएगा. ठीक है. Deterrence serves as a major tool in maintaining general law and order in society, especially from perspective of crime. Criminal acts are penalized so as to deter individuals from repeating it or even entering into it in the first place. So deterrence is that I am giving such a strict punishment or I am setting such a strict law that there is a deterrence, an example set out which now prevents further public from repeating the act or from entering into it. Okay, they may not think of doing it and they may not do it. So to set an example of such strictness, I am penalizing or I am giving such a strict punishment to the accused in this case. For example, if I give a punishment to a person, a very, person has committed a theft, say, and I am giving him a strict punishment, so that will be set as a deterrent. For murdering someone, if the court is giving him the capital punishment that you will be hanged to death, because of you, this family has suffered the loss of a person, so now your family will also suffer a loss of you. So if I am setting such a strict punishment for murdering somebody, then that would be a deterrence that people will not think of murdering the other person now, because they know if they murder someone, they themselves will be killed. right? So deterrence is just an example to be set up through strict punishments or penalties so that further individuals or people may not repeat or attempt to repeat that act. Incapacitation objective of this is to segregate criminals from rest of society. For crimes committed, they suffer a kind of banishment by staying in prisons, and in some cases they are also subject to capital punishment. Capital punishment may be death, life imprisonment, जो बहुत ही एक्सट्रीम सिचुएशंस में करी जाती हैं, जो सबसे ज़्यादा मतलब सबसे ज़्यादा एक्सट्रीम होती हैं और पर्टिकुलर केसेस में ही कैपिटल पनिशमेंट दी जाती है, विच इंक्लूड किसी को फांसी लगाना, किसी को लाइफ इम्प्रिजनमेंट देना. सो दैट इज़ ऑल कैपिटल पनिशमेंट. Incapacitation means to separate the criminal community from the rest of the society. And obviously, we all know that for the crimes they commit, certain period of prison term that they would have to serve, that is decided in IPC, that is written in IPC, that for such and such crime, this much amount of prison term the person has to serve. So they live in prisons, and also in some extreme situations, not extreme situations, but in some extreme crimes that they commit, murder hua, rape hua, for that they get capital punishment. Until the time obviously the case is going on in the court, the case is pending in the court, they have to live in the prison. Rehabilitation aims at transforming an offender into a valuable member of society. I don't know whether you know this or not, that recently in the prisons, some rehabilitation facilities have started, right? The prisoners, they wash their clothes, they do that labor work, ब्रिक्स उठाकर एक जगह से दूसरी जगह जाना, जो जनरली हाउस कंस्ट्रक्शन में लेबरर्स करते हैं. ये सब काम उनको सिलना और डिज़ाइंस बनाना, ये सब काम उनको सिखाए जाते हैं, सो दैट when they have their prison term ended and when they go back into the society, into the mainstream society, then after they can live and they can earn money on their own. So in the prison itself, they are serving the prison term also, and sometimes they are making money in the prison also, and they are learning that how to earn money when they go out of the prison into the mainstream society, so that after serving the prison term they can turn themselves into a valuable member of society, ताकि उनका दिमाग अब फिर से क्राइम कमिट करने में ना जाए और वो एक सही और अच्छे मेंबर बन सके सोसाइटी के. ठीक है. इट्स प्राइमरी goal is to prevent further offense by convincing the offender that their conduct was wrong. Restoration, this is a victim oriented theory of punishment. Goal is to repair through state authority any injury inflicted upon victim by offender. So restore, that means to repair or to restore the any sort of injury which is upon the victim by the accused, and it is by the government or state authority. For example, one who embezzles will be required to repay the amount improperly acquired. Restoration is commonly combined with other main goals of criminal justice and is closely related to concepts in civil law, that is returning the victim to his or her original position before the injury. That is a sort of compensation. Compensation में यही होता है कि उतना ही अमाउंट विक्टिम को दिया जाता है by the accused, so that his position can be same as it was before the injury was caused. For example, if I have a person A and B, I think I gave you that example, that vehicle was damaged because of B's act. So now B will have to pay the amount of this vehicle, and that was the CP of the vehicle, because before the accident, before this injury, the price of the vehicle was 50k for suppose, then B would have to pay this 50k amount to A, because that was the amount of the vehicle before the injury. So this person will be brought back to the situation or to the position where he was before the injury. So that is compensation only, right? So justice had to be done in a way that relates to returning the amount of money or returning the victim to his original position before the injury. That is restoration, to repair or to restore his position, right? Restore. What is criminal law? Purpose of criminal law in India is first, to define a variety of crimes; second, to prescribe appropriate punishment for each crime; third, to lay down suitable investigation and trial procedures. Okay, so what is criminal law? Purpose is, firstly, we have to define that what all crimes are there, right? Theft, murder, cheating, fraud, nuisance, trespass. Trespass is also a crime. Criminal trespass बोलते हैं उसको, ठीक है. Then we have murder, then we have dacoity, robbery. So all these things. So we have defined that what all will be classifying as crimes, and if we have crimes, then to make sure that these crimes do not occur so often in the society, because that will disturb the law and order, right? So for that we have certain amount or certain period of punishments for each type of crime that we have. For cheating we have a different punishment, for murder we have a different punishment. So punishment can be in the form of a prison term or fine. Third, that what will be certain procedures or processes or stages, you may say, through which the police or the authorities have to go for proper investigation and trial of the accused, right? आप पहले FIR file करेंगे, then you will be searching, there will be issuing of warrants, search warrants, right? And then you will be able to search the body or property of the person. So that all, because of the arrest warrant only, you will be able to arrest that person and bring to the prison or to the police station. So that all procedures are also mentioned, and trial person will be trial within 24 hours at the nearest magistrate or nearest court of law. So that all is criminal law. Sources of criminal law. There are several legislations dealing with criminal law. Two important sources are Indian Penal Code 1860, which defines various crimes; Code of Criminal Procedure 1973, which lays down the procedure for both police to investigate crimes and for trial of offences. So, these two things are mentioned in IPC, and this thing is mentioned in CRPC. This is CRPC, Code of Criminal Procedure 1973, and Indian Penal Code IPC 1860. Okay. In addition, the following legislations are important: Indian Evidence Act 1872, which stipulates the kind of evidence admissible in court. See, Indian Evidence Act. So what kind of evidence a lawyer can produce to save his client, or what kind of evidence can be produced in courts at which situation. So that all is in Indian Evidence Act of 1872. Special criminal laws passed by Parliament or state legislatures, such as Prevention of Corruption Act, Food Adulteration Act, Dowry Prevention Act, Commission of Sati Act, etc., Each of these laws defines crimes that are in addition to those defined under the IPC. IPC के अलावा there are these special acts, corruption, food adulteration, dowry prevention, all these which were time to time being passed by the parliament or state legislatures. So all these acts, the crimes or the punishments that they define, they are also very much admissible in the courts. Okay, so these acts, they can be any acts, the triple talaq law or any such act which are passed due course of time by the parliament or state legislatures are admissible in the courts of law. Then we have IPC, CRPC, all these special acts, statutes which are passed by government. These are the sources of criminal law. I think it's clear. So you remember IPC, CRPC, main difference is IPC, crimes and punishments. Crimes are classified and punishments are defined for each type of crime. CRPC, the procedure to investigate for the crime. See, इसमें तो प्रोसीजर लिखा ही हुआ है ना, क्रिमिनल लिखा हुआ है, तो कोड ऑफ क्रिमिनल प्रोसीजर इज दैट व्हाट वुड बी द प्रोसीजर टू इन्वेस्टिगेट. IPC is what is crime, what punishment, and CRPC is how you have to investigate. IPC answers the question of what and CRPC of how. Now we come on to IPC. IPC passed in 1860, came into force in 1862. It is the main criminal code in India. It was drafted after consulting various existent criminal codes in world such as French Penal Code as well as Code of Louisiana in US. Now you see, IPC was passed in 1860, came into force 2 years later, that is in 1862. We were not independent that time, right? So it is very clear that we had not framed it. It was framed by Lord Macaulay. It was framed by Lord Macaulay. Okay? We had not framed it. IPC was framed by Lord Macaulay, and if you see this year 1860, it is very near to the first war of independence of 1857. So after this revolt, this upthrust, this code was made by the Britishers. That अब जो कोई क्राइम करेगा वो इस बुक के हिसाब से हम उसको पनिशमेंट देंगे. ठीक है. Now this was till now uniformly applicable in all states except J&K, but now it is also applicable in J&K because that special status has been removed. I also told you the special penal code for this state, that was Ranbir Penal Code, right? Okay. The Indian Penal Code is divided into 23 chapters comprising above 500 sections. I think this is not much important, but depends upon school to school what they may ask. So IPC divided into 23 chapters, over 500 sections. Code starts with an introduction. Every book which you buy or which you see, first page is what? Its introduction part. Provides explanations and exceptions used in it, and then lists a wide range of offenses. So there is an introduction part which provides explanations, exceptions to the code, that is IPC, and then we have a wide range of crimes that are defined in it. Broad classification of crimes under IPC: crimes against body, murder, culpable homicide not amounting to murder, kidnapping, abduction, assault. Kidnapping, abduction, किडनैपिंग आपको पता ही है, abduction बहला फुसला कर हम उसे उठा कर ले गए, assault किसी को मारना, ठीक है. मर्डर तो एक बंदा ही मरेगा, so that is against body. Culpable homicide not amounting to murder, this also is a very grave, you can say, a grave injury to the person. Grave injury is also a crime that also will be against body. Crimes against property: dacoity, robbery, burglary, theft. Crimes against public order, riots, arson, dange karna. That is obviously against the law and order of the society. Economic crimes, cheating, counterfeiting, नकली नोट बनाना, नकली coins बनाना, नकली currency बनाना, that is also a crime. Counterfeiting, cheating, fraud, bribery लेना, that is all economic crimes. Crimes against women can be rape, dowry, death, cruelty by husband and relatives. And these two things are generally dowry, death, cruelty, mental or physical cruelty, both. That can be under the Dowry Prohibition Act. Molestation, sexual harassment, importation of girls, crimes against children, child rape, kidnapping, abduction of children, selling or buying of girls for prostitution, abetment to suicide, infanticide, feticide, बच्चे को मार देना और fetus में ही मार देना, that is feticide. IPC covers substantial part of criminal law in India. It defines various common criminal offences. For example, it defines murder, theft, assault, and a number of other offences, and also stipulates appropriate punishments for each. For instance, offence of theft is defined in following language in section 378. So, sections are very important. IPC sections are important. Section 378 defines theft. Remember that. Whoever dishonestly intends to take any movable property out of possession of any person without that person's consent and with that intention moves that property in order to commit such taking is said to commit theft. That means if a person intends to take some property out of the possession of a person, obviously theft is without the permission. अगर permission से लेंगे तो वो borrowing हो जाएगी, right? Theft means without the permission of the person, out of the possession. So you are intending to take an article C, for example, from the possession of person A without the consent or permission of A, and for that intention you are moving the property out of the possession. You have an intention to move that property, and to fulfill that intention you are now moving the property out of the possession of person A. Then that would be said as theft. And you must have a dishonest intention also. Okay, dishonest intention to move, obviously there would be theft of movable property, something which can move from one place to another. You have to move it. So, dishonestly moving any property out of possession of a person without his consent, and for that intention you are also now moving the property. You have an intention to move the property, and for that intention you are moving the property out of the possession. That is known as theft. In other words, crime of theft is committed if someone intends to take someone else's property and indeed takes that property without the other person's consent. Merely intending to take property without actually going ahead with it does not amount to theft. Punishment of theft is given in section 379. So you see definition of theft given in section 378, punishment of theft given in section 379. Whoever commits theft shall be punished with imprisonment for a term which may extend to 3 years, or with fine, or with both. So I will keep it till here. From this portion I will be doing in the next video.